The Supreme Court is hearing the pleas in the Waqf Amendment case. In a significant development today, a bench of Chief Justice Sanjeev Khanna and Justices Sanjay Kumar and K.V. Vishwanathan have proposed to stay certain key provisions of the contentious law. So what are those provisions that have been kept on the back burner at least till the next 7 days? Number one, there is not going to be any change to the nature of Waqf properties, which means that for 1 week, the Waqf by user provision that had been denotified according to the new law, that had been made illegal according to the new law, that change will not take place. There will be no new appointments to Waqf boards. Remember, the new amended law mandates that there should be 2 non-Muslims on the board, on the Waqf Council, but no new appointments are going to be made, which basically means that there is going to be status quo when it comes to these particular provisions. There will also be no denotification of certain Waqf properties for now. My colleagues Harish and Dipankar join us for more. Harish, first of all, tell us what are the provisions that have been stayed for the next 7 days and what will be the implications of that?
Yes, in fact, a big order from the Supreme Court as far as nearly 120 petitions challenging the Waqf Amendment Act is concerned. In fact, the Supreme Court has formally sought a response from the centre, from all states, and also Waqf bodies as far as these petitions are concerned. And more significantly, Priya, the Supreme Court bench of Justices, Chief Justice Sanjeev Khanna, Justice Sanjay Kumar and K.V. Vishwanathan has recorded in the order the assurance given by the Solicitor General of India, Tushar Mehta, that till next date of hearing, any Waqf which has been registered, notified and gazetted, or which is born out of any court order or decree, that will not be denotified, number one. Number two, no appointments will be made to any state Waqf board or central Waqf council because and that has been recorded. And the Solicitor General Tushar Mehta said that anyways for the next 1 week nothing is going to happen. That assurance the Supreme Court can record in its order. So in a way the Solicitor General said that since the Supreme Court was going to pass, as per yesterday's oral observations, very drastic orders which will affect the rights of thousands of whose properties have been grabbed through Waqf by user. The Supreme Court should not pass a drastic order. So there is some meltdown from the Supreme Court because yesterday 3 drastic orders were being proposed. That would have been the Supreme Court's orders. But today the Supreme Court has recorded the Solicitor General Tushar Mehta's assurance that till the next date of hearing all these will not happen, and the Supreme Court has given an opportunity to the centre to file a detailed affidavit within 1 week, that is 7 days, and further 5 days for the petitioners to file their counter affidavit, that is their responses, and the hearing has been fixed for the date, the week commencing May 5. So these are the developments as far as the hearing in the Waqf Amendment Act is concerned.
Dipankar, now Harish is telling us that the court has said that those properties that are registered and that are gazetted will not be acted against. The centre or the new law does not take effect at least for the next 7 days. But what happens to the other properties that are not registered or gazetted?
Well, clearly the Supreme Court has tried and maintained a status quo regarding the properties that have been denotified or are the properties of Waqf by users. So basically it has said that all the properties that are Waqf properties will not be denotified, will remain status quo. There will be a status quo as per the assurance that has been given by the Solicitor General of India. It is very clearly the Solicitor General of India has stated that all the properties of Waqf will remain as status quo and will not be denotified. Apart from this, the Solicitor General has also given an assurance regarding that there will be no further appointments in the councils, that is the State Waqf Board and the Central Council of Waqf. So these assurances have been taken on record by the Supreme Court of India, and they have sought a response from the Solicitor General of India, that is the Union of India, and all the other members of all the other state members who were there in this petition, and have said that a reply should be filed within a period of 7 days. As the Solicitor General of India during the hearing had also said that within a week there would be nothing much would change. So 7 days time has been given by the Supreme Court of India to all the parties, to the respondents in the case, to file their response, and 5 days further from that have been given to the petitioner to give a response regarding the reply that would be filed by the Union of India and the states. So these are the clearly indications that no Waqf property that is there will be denotified, and no further appointments would be done in the Waqf case as per this assurance that has been given by the
Harish, does that mean a blanket stay on any movement forward, or are there any exceptions that are out of the ambit of this interim stay?
Yes, in fact, Priya, there is actually a tone down from yesterday. What the Supreme Court had was contemplating, mulling yesterday, because remember as per the new act, any property, any Waqf by user in dispute or in a government land, that can be removed, that can be denotified. So yesterday the Supreme Court said it was seriously contemplating issuing a direction that the clause that says that once the collector or a senior government official begins a probe, automatically that property will not be considered a Waqf property. Today, significantly, that order has not been passed. That is a big relief for the centre, because most of the properties fall in that category. Because the Kapil Sibal, appearing for several key petitioners, had argued that how can a collector be the adjudicator, because collector in a dispute between the government and a particular Muslim individual will definitely support the government. So in a way, the government is both the litigant and the judge. That provision will continue. That is very important for the government. That provision has not been touched upon. Yesterday, the Supreme Court had even tried to said that it will pass this aspect also, saying that once the collector begins a probe, that Waqf property cannot be denotified. That will continue to be a Waqf property. So that has been omitted from today's order. So today's order touches upon only two aspects. One, no appointments to state Waqf boards, no appointments to Central Waqf Council, because the Supreme Court is of the view. Supreme Court had even asked Solicitor Tushar Mehta, will you allow appointing any non-Hindu or a Muslim in a Hindu endowment board? Come out openly on that. So that is why we are questioning the clause which says that non-Muslims can also be part of state Waqf board and state and Central Waqf Council. And why this restriction on denotification of Waqf by user is because Supreme Court yesterday commented that you should not rewrite history. There are several properties by user hundreds and 200 years old. They cannot produce any documents. So at this juncture, when the Supreme Court is adjudicating the matter, examining the validity of such an important sensitive act, this certain properties should not be denotified. And today in the list are, the Supreme Court said SG should give an assurance that all Waqf properties which are registered, notified and upheld by a court or in a decree, that cannot be denotified.
Dipankar, now tell our viewers how these proposals were made by the centre itself. The SG, when speaking to the court, said that we are okay if we do not go ahead with all the provisions for a while, but give us 7 days time to file an affidavit. What can we expect from the affidavit that will be filed a week later?
Well, clearly the Solicitor General sought time from the Supreme Court of India to file a reply to the petitions that has been filed by the various people who are opposing the Waqf Act, and the Solicitor General of India said that he requires 7 days' time while giving these assurances that there will be no denotification of properties which are already gazetted or notified or decreed by...
Stay on with me, Harish and Dipankar. We have also been joined on the broadcast by Swapnil Kothari. He's a legal expert. Sir, we'll come to you. But first of all, let's take a look at the political reactions that are coming in. First of them being from Asaduddin Owaisi. Listen in.
The Honorable Supreme Court, as rightly pointed out by my counsel, Mr. Nizam Pasha, the Supreme Court has said that the Central Waqf Council and the State Waqf Board will not be constituted. Waqf by user cannot be deleted. During the deliberations of the Joint Working Committee, I have given a Dyson report opposing all the amendments that were proposed by the government. And during the debate in the Parliament of the consideration of...
Okay, Mr. Swapnil Kothari, my question to you is, the court has said in its interim order that those properties that are registered and gazetted under Waqf by user will not be denotified. So does that mean that action can still be taken against the other properties?
Well, what it means is that the government is free to launch an investigation and post 7 days when it files its reply. And then when it continues to argue the matter, at that time it can show to the Supreme Court and even include this in the part of the reply, which I believe the government should be ready with some of those properties which are not registered and which don't have the proper status of the law. So at that time, in its reply, it could include those properties and then it could argue. Because right now, if they were to take action for denotification, etc., there is no bar on denotification. But I don't know, given the fact that the matter is sub judice, you try to do this beforehand. Because what it could be perceived as that before the judgment comes of the Supreme Court one way or the other, and before you file your reply, we've already started taking the action. So generally, the government will be ill-advised to do so. And I believe the lawyers who are helping out the government who are there to say, Tushar Mehta, I don't think he will advise that you please go ahead and do this when the matter is sub judice.
Okay, so center is...
Yeah, so please wait, hold on to your horses. That is what Tushar Mehta would advise them, that don't do this right now, because if I were to be there in his position, I would advise the government to do so, that let's put this on paper, let's put this in our affidavit, let's put this on a reply, and let's argue with this, let's put it before the Supreme Court, and let there be an actual stamp of the Supreme Court in the form of an order, saying that, okay, you conducted these investigations, these were never registered, they did not follow the process of law for registration, so they should stand denotified. So एक Supreme Court के order अगर जब आ रहा है, आज नहीं आएगा, कल आएगा, तो क्या जल्दी है इसको अभी immediate denotify करने की क्या जरूरत है?
Right, center definitely.
I believe that status quo रहने दो ना. Status quo means status quo. फिर
yes.
then you are reading into the order. Then again you'll have the opposition going into the saying that these people have started denotifying. So please now clarify the order. Why do you want that?
Yes, so center definitely also is moving with caution on that matter, but we are